What to do if you've been denied bond. That's the subject of today's Need to Know. Need to know what? Need to know the law. Dan McDermott here, McDermott Law Group, McDermott Mafia, McDermott Militia, all one and the same. Today's Need to Know takes place downstairs here. I'm in front of this computer because we have a lot of Zoom court going on, especially for Cook County right now. A lot of court is being done by Zoom. We appear on computer. That's why I've got my gym shoes, these kicks on, these jeans on underneath the computer screen, but everything up is pretty professional, including my glasses, which I have to wear as of this year. Anyway, with respect to bond and setting of bonds, many people are denied bond or denied bail. It's not what generally happens, but in very serious, with very serious allegations, it very often happens. And it's kind of sad because really, often the reason for denying somebody bond is nothing more than the actual allegations that the prosecution is presenting to the court. So in other words, the judge says, okay, state, what are you asking for with respect to bond? And the state's like, well, you know what? He shouldn't be given a bond. He did this, he did this, he did this, he did this, he did this. It's basically like they're able to put on their case. They're able to try the case without trying it. They basically say he did all these different things, and they talk about all the different charges that are brought against him, and the fact that he was arrested for all these charges. And then basically, the judge turns to the defendant or the defense attorney and says, okay, well, why should he not be given a high bond, or why should he not be denied bond? And the defense says, well, she has been living in this state for so long, has been employed for so long, has this many children, has a spouse, has all these other things, and basically you want to paint a picture of your client being a good person. You really don't get to go ahead and say, well, you know what, Judge, it's because this didn't happen. What the state said, they're just allegations, they didn't happen, here's why they didn't happen, we can prove this, we can prove this, we can prove this, because generally the judge is going to say, you know what, defense counsel, this isn't a trial. That's generally going to be the response to the judge. The judge is going to say, you're going to have a time to try the case. I want to know why his bond should be low. And it seems that it's not all that fair if you think about it, because you don't go ahead and get to present any evidence, any evidence for in support of your defense or anything else, because the judge doesn't really want to hear that often. So really, you're sticking to these, these good guy type factors, circumstances that you want the court to take into consideration. With respect to denying bond, it has to be done in the state of Illinois, which is where we're still at for the purposes of this Need to Know. It has to be done pursuant to statute. And the statute in Illinois says that in order for there to be a denial of bond, it has to be upon verified petition, which means in English, the prosecutor, the state's attorney, has to file some sort of written motion or written pleading saying that bond should be denied. And then there are certain reasons that have to be set forth in there, and the court has to find these reasons exist to be able to deny bond. So when you're getting charged with something for the first time, not necessarily your first criminal charge ever, but when you're being charged with something and you're in court for the very first time for bond, you have to, in order to be denied bond properly, there has to be upon verified written petition, which means that they had to file something. Very often they don't file something. Very often they're asking to deny bond. There are many times that bond is denied when nothing's been filed. That's a reason to go ahead and attack bonds, to be able to say, hey, a bond should be set because they never filed a written motion. You can also go ahead and address bond if in fact bond was denied. You can also go ahead, not just on that basis, but you can always go ahead and ask that bond be reduced, or in the case that in the event that it was determined there was going to be no bond, that bond actually be set. You have to file a motion, you have to go to hearing on it, you have to serve the state, a whole bunch of other things. If you need to know any of that stuff, obviously just give me a call. I'm talking way past the time I'm supposed to be talking, and I still have 2 more Zoom court appearances left for the day, for the morning actually, then I got to start the day. So until next time, hope you're staying safe and well. Talk to you soon.